Ladies and gentlemen, we are running a little late, and I would like to ask you to take your seats, and we will want to introduce our distinguished next speaker for this conference. And I wanted to introduce to you Professor Bat Ami Zucker. She has a law degree and is specialized in American legal history. She is Professor Emeritus at Bar Ilan University in Israel. Her books include United States Aid to Israel and its reflection in the New York Times and the Washington Post, 1948-1973. Also, In Search of Refuge, Jews and United States Consuls in Nazi Germany, 1933 to 1941, and also a book titled Cecilia Razovsky, American Jewish Women, Rescue Operations, 1933 to 1945. Professor Zucker's paper, the title of her paper, is Immigration and Refugee Policy of the United States on the Eve of World War II. It is a great pleasure and privilege for me to introduce here Professor Zucker. Thank you.
Good morning, everybody. First of all, I want to thank the organizers. I know that it's usually people say such things, but this time I really mean it. It's one of the best organized conferences that I have been, and I've been in a lot. So thank you. Another comment that I would like to make clear before we start is the title of the paper is a little bit misleading. It says the American immigration like this, immigration and refugee policy. As a matter of fact, the United States had an immigration policy, but no refugee policy. There was nothing like a refugee policy. As a matter of fact, only in 1980, a Refugee Act was enacted for the first time. So what I want to show you what they did in order to avoid the problem or the issue or the people who were victims of the Nazis and were actually refugees in their own country. Okay, let's start. President Roosevelt himself portrayed his job or his image as the champion of the forgotten men. He built his entire public image around the precious American moral value of helping the downtrodden. Yet, this is the same President Roosevelt who chose to turn a blind eye to the plight of the German Jewish refugee. It was not just a question of FDR's personal inconsistency, but also the broader problem of American attitudes toward refugees. The question of how to respond to the Jews fleeing from Hitler constituted a serious moral dilemma, as well as a test of America's basic beliefs. In a sense, America's restrictive immigration policy defied the country's professed commitment to freedom and democracy. One could argue that by denying this commitment, the United States was in effect compromising its own raison d'etre, thus America's attitude toward German Jewish refugees in the 1930s may serve as a test case, not only for American immigration and refugee policy, but also for understanding the role of humanitarian consideration in the political decision-maker process in the years leading up to World War II. I'll start in a short background of immigration earlier to the 1930s. Until 1882, by the way, that was the first year that an act restricting Chinese workers to come to America, but that was in 1982. Until then, immigration to the United States was largely free and unregulated. And anyone who wanted to come to the country could do so if he or she was healthy and could pay the cost of transportation, something like $12. An immigrant could cross if he was healthy and had the expenses, which were not very, very high. But since 1820, when the United States formally began keeping track of immigration, it has absorbed millions of legal immigrants, and all of them, most of them, all of them were born in 155 countries. America's doors were open to almost all who sought entry, making the United States, and this is important, afterwards we'll compare, and making the United States the torch of hope for the oppressed and persecuted of the old world. But the 20th century witnessed a major change. The waves of immigrants from especially Eastern Europe triggered xenophobic and anti-Semitic reactions, which resulted in a series of restrictive immigration laws. The new laws that were enacted during the 1920s were racial in nature, establishing quotas in accordance with racial preferences. Furthermore, whereas the idea of asylum was a long-standing American tradition, this concept was not written into the new immigration laws. The legal basis for immigration policy was defined by two pieces of legislation, which overturned the traditional open door and policy and essentially closed the gates to all but a favored few. The first was the Regulating Immigration of Aliens, an act of 1917. It spelled out for the first time the basic restrictions that could be used to exclude immigrants on grounds of physical, mental, or moral defects, or for political and economic reasons. It also contained what would turn out to be the most used and most difficult hurdle to overcome, the likely to become a public charge clause, or as we call it, LPC. The vague elastic clause enabled the American Council abroad, or around the world if you want, to keep out as many applicants as possible on the grounds that they would be an economic burden on the United States. The second bill was the National Origin Immigration Act of 1924, also known as the Johnson-Reed Act or the National Origin Act, reaffirmed all previous restrictions by bearing the mentally, physically, and morally undesired classes, of course, including the clause that I mentioned earlier, the LPC. What turned out was, the result was that the Johnson-Reed Act, which was obviously meant to pander to racist prejudices, was intended to be restrictive, whereas the 1917 Act described itself as regulating immigration. The 1924 Act proclaimed that it aimed to, quote, limit the immigration of aliens into the United States, end of quote. It set up quotas according to the national origin of the would-be immigrants based on the number of people of that nationality who were already living in the United States. The 1924 law marked a formal abandonment of the open door tradition, replacing it with the concept of, quote, America for Americans. It introduced a quota system. It also established for the first time that visas were required for entry to the United States. Before you came to the United States and you got permission or to get inside, or you were rejected. Now it was necessary to obtain a visa not after traveling, but before you can get a permission to get to the United States. The process of issuing a visa was used both to operate in accordance with the quotas and to allow for the administrative screening. The Act also grants exclusive responsibility to issue immigration visas solely to the consular officer. Many of the difficulties of applicants encounter could be attributed to the biases of consular officers and to red tape. It was the consul and he alone who determined who would be admitted to the United States and who would be excluded on his own judgment. For instance, there could be two consuls in the same office or the same consul on different days, and each one of them interpreted the clause in a different way. So it was, and he didn't have to explain, he got all the discretion that he needed. He was the one to decide. Since there was no precise definition of how much money an applicant should have in his position in order to avoid becoming a public charge, and there was no clear rule as to how long an applicant had to prove himself sufficient, much was left to the discretion of the individual counsel. The wording of the LPC clause was vague enough to allow the counsels to use their own judgment in interpreting them. The counsel's interpretation of the existing legislative proved a most efficient tool of preventing the entrance of refugees without the need for legislative action, as we shall see. Hitler rise to power in January 1933 completely changed the dynamics of the immigration issue. Now it was a matter, and I'm not exaggerating, of life and death. Thus, it is no surprise that President Roosevelt faced a completely different situation. The Jews of in Germany began suffering brutal persecution as soon as the Nazis came to power. Now large numbers of German Jews wanted to come to the United States, fearing for their lives. The German Jewish situation required an emergency solution. Yet, just as the plight of German Jews was intensifying America and the rest of the world were closing their doors. Anti-immigration sentiment, anti-foreign sentiment, and spread anti-Semitism. I'm sorry, it's not what you say. It was spread anti-Semitism in American society, especially around Washington. We're greatly felt, and to add to it, the worldwide depression, all were obstacles to prevent greater immigration. It was the tragic misfortune of these refugees that the event in Germany coincided with grave domestic problems in the United States, and the general public opinion, which was at best largely indifferent to international problems, including the plight of German Jews. So German Jews seeking to immigrate to the United States soon became the victims of individual arbitrary decisions by US consuls, which were often not substantiated by facts. This resulted in a dramatic cutback of immigration to levels that were even far, but really far. Somebody gave the example of 5,000 against 25,000 that the quota allowed. So it was really, the quotas were just 1 year, 1939, it was filled. Otherwise, it was really below the quota. It is interesting to note that what had been practiced by the consuls without an official directive was confirmed in writing in the summer of 1940 by Assistant Secretary Long, who instructed the consuls to use delays deliberately as an instrument to reject applicants. Quote, "We could do this by simply advising our consuls to put every obstacle in the way, which would postpone and postpone and postpone the granting of visas." By 1937, Visa Division Officer John Simmons could inform Pierre Point Moffat, Chief of the Division of Western Affairs at the State Department, that these administrative practices had resulted in, quote, "immediate and considerable reduction in immigration." The assignment of exclusive responsibility for issuing visa to the consular officer had also a significant impact of the balance of power between Congress and the executive bodies with regard to immigration policy. By the end of the 1930s, it was the executive and not Congress which in fact controlled the formulation of immigration policy. Another powerful obstacle to immigration, and in my point, a major one, was the absence of a category of refugee in the immigration laws. Whereas asylum was always considered an American tradition, it was never actually written into immigration laws. Under the laws, refugees were classified the same as any other immigrants and were accorded no special treatment. Despite many appeals by Jewish leaders, the Roosevelt administration consistently refused to recognize refugees as a special class, or for that matter, as any kind of separate class from other types of immigration. As far as the Roosevelt administration was concerned, there were no refugees. For legal purposes, immigration law did not single out refugees for mention. It was convenient for the State Department to place the responsibility for ignoring the Jewish plight on statutory prescriptions. After all, as Assistant Secretary Messerschmitt emphasized in October 1938, quote, "The statute on the books were the law over which the Department of State had no control. The official position of President Roosevelt and the State Department was to express verbal sympathy for the suffering German Jews, while coldly insisting that refugees were not the responsibility of the United States. The German Jews were a general and not a specific American responsibility." Just a month after the Kristall pogrom, Messerschmitt wrote to Consul Raymond Geist in Berlin, who replaced him, reminding him that America could not afford, quote, "to become a heaven for all the distressed people in the world. Not only would such a policy be wrong and could bring to the already unsatisfactory relation with Germany, it would also, now this is for you, it would also intensity anti-Semitism in the United States." In a letter around the same time to Supreme Court Justice Felix Frankfurter, Messerschmitt gave an additional reason for restriction. Creating a separate category of refugees, Messerschmitt insisted, would cause harm to the Jews themselves. He claimed that Jewish immigration would encourage anti-Semitic groups to claim the Jews intended to increase the strength of the Jewish population in America. In other words, keeping them out of America was for their own good. In response to inquiries about German Jewish refugees, Assistant Secretary Carr declared as early as April 1933 that there was no basis in the law for the issuing of instructions undertaking to provide special treatment for the class of aliens known as refugees. He emphasized that the immigration laws contained no provision for the benefit of aliens who sought refuge in the United States to avoid religious or other persecution, apart from the exemption of such person from the necessity from the necessity of passing the literacy test. He said that this sole exception, Congress did not intend to make any other provision for this special class of persons. Thousands of answers sent by senior and junior State Department officials to request for the establishment of a special class of political refugees from Jews and not Jews, liberal people who were worried about the fact that there is no plan of rescue, only the Immigration Act, which were, as I told you before, were restricting in any possible way. So to the thousands of appeals, of requests to establish a special class of political refugee, the answer was always the same. Refugees from Germany could apply for immigration visas, comply with the complicated requirement, and wait their turn on the long quota list like any other applicant. And the list was very long. To make matters worse, The Roosevelt administration never acknowledged the relevance of the situation of German Jews to the issue of immigration. In private correspondence among themselves, visa officials usually referred to German Jews as refugees, but in official documents, the term was usually omitted. Indeed, Visa Division called E.B. Coulter in 1934 specifically recommended to Assistant Secretary Carr that it would be, quote, preferable to avoid any reference to refugee in the regulation, since it would eliminate the need for consuls to determine whether applicants were indeed refugees and thereby give them greater leeway. Another, his colleague, Wilkinson, presented similar objection. In his view, making the United States an asylum, quote, for so-called political and religious refugee would produce untoward international repercussions. And Malcolm Lemberg, American vice consul in Hamburg, stated in 1934 that refugee and victim of persecution were not entitled to any kind of preference by law since, quote, any systematic attempt to erect a pseudo-preference group and to expedite the admission of this group in advance of other immigrants who are legally of the same classification would ultimately be held to conflict with the provisions of the Immigration Act of 1924. This orientation, joined by State Department in Washington and the consuls who were exposed to the mistreatment of the Jews on a daily basis, makes it difficult to understand the repeated refusal to recognize refugee as a separate class entitled to preferential treatment. The official attitude toward refugees could not conceal the fact that the United States, even as late as 1941, did not have any refugee policy. Dr. Barbara McDonald Stewart points out, quote, refugee in Washington meant alien to the bureaucrat, secret agent to the military men. Both definitions provided justification for the policy of barring the doors. For too many Americans, a refugee meant a mouth to feed, an unemployed worker to locate, a source of anti-Semitic irritation, a potential harbinger of alien ideologies, or a break in the immigration dikes. Now, I want to share you my conflicts. You know that I know that I promised to give you details of the immigration policy, but what is more important is to let you know that there were other groups of non-quota immigrants, which usually we don't pay attention to. So I decided not, if you ask me afterwards, then I'll answer, but I'll give you the details. But I've decided to deal today with the groups, the non-quota groups, which are less known and could have served, if used well, to bring more and more Jews into the United States. So while most historians have understandably focused their attention on the details of the immigration quotas and how they were implemented, there is another type of immigration that is often overlooked. It is not widely realized that there were, in fact, 6 categories of foreigners who could legally enter the United States outside the quota system. They were called the non-quota immigration, and they represent an important missed opportunity to save many Jews. The first category was a husband or wife of an American citizen or an unmarried child under 21 years of age of an American citizen. That when we compare this situation or this category to the other categories of non-quota immigration, this one was the smoothest and the simplest. In order to make it happen, the American citizen had to file a petition with the immigration commissioner asking that his spouse or child be given a preferential status. Since the purpose of this exemption from the quotas was family reunification, and since the number of immigrants involved was not very large, there was no significant opposition to it. There were 2 additional categories that involve very small numbers. There was the resident, the alien resident, someone who had lived in the United States for a while but not obtained citizenship. If such a person left the country and then wanted to return, he could do so outside the quota system. The same is true for American women who lost their citizenship because they married foreign citizens abroad. They did not receive priority treatment as did spouses of American citizens, but again, the numbers involved were very small. And now we get to the main groups. As the situation of Nazi Germany deteriorated and the waiting list at the American consulates grew longer, an increasing number of German Jews tried to gain admission by being classified under one of the other 3 categories of non-quota immigrants: professors, students, and religious ministers, rabbis, cantors. We'll start with the professors. In order to qualify as a non-quota immigrant, a German Jewish professor had to prove that he had worked continuously at a college, university, academy, or seminary for at least 2 years before the date he applied to immigrate. The obvious problem with this requirement was that many German Jewish academics were seeking to immigrate precisely because they had been fired during the Nazification of German university. Nevertheless, the Roosevelt administration refused to accept such circumstances as a reason to exempt the applicant from the 2-year requirement. There was yet another catch-22 the German Jewish professor faced. They had to prove that they had been offered a position at an American university. But if it was an offer for a limited duration, that was not good enough, and the applicant had to go through the same burdensome procedure of all other applicants to show that he had guarantors in America who would support him so he could not become a public charge. It was only if he could prove he had been offered a permanent appointment that he would qualify. But as you all know, the most common procedure among American universities, at least at that time, was to offer appointments that were of limited duration. I'll give you maybe one example which is very famous. The person itself is famous. One of the many cases in which distinguished scholars were not able to qualify for non-quota visa was that of Professor Victor Klemperer. By the way, his diaries were translated into English not recently, and they make a wonderful source for a life of a person who was born Jewish but converted to Christianity back in 1912 and was married to a Christian. But because of his Jewish lineage, he was persecuted by the Nazis. In 1938, Klemperer applied for a non-quota visa, but was denied. Why? Because he had been fired in 1935, so he couldn't meet the requirement of 2 years of employment immediately preceding the application. Hebrew Union College, another example, in Cincinnati, encountered many similar problems when it undertook its Refugee Scholar Project, which tried to help German Jewish scholars reach the United States between 1935 and 1942. Consider the case of Arthur Spanier, a noted scholar who had served as an Hebraica librarian at the Prussian State Library, and later as a teacher at the Hochschule für die Wissenschaft der Judentum in Berlin. But the consul rejected his application on the grounds that he was primarily a librarian rather than a college professor. Even a personal plea by a Supreme Court justice was not enough to move the administration. In early 1939, Justice Felix Frankfurter tried to intervene on behalf of a Dr. Kurt Proskauer, a dentist who had been offered a position as a professor in the New York Academy of Medicine. The Visa Division Chief, George Warren, rejected the appeal on the grounds that Proskauer had not previously worked as a professor. He told Frankfurter that Proskauer would have to, quote, await his turn under the quota with other applicants for non-preference German quota visas. For the feminists among us. By the way, the professor exemption, which was a part of the 1924 Immigration Act, allowed the wife and unmarried children of a male professor to accompany him as immigrants. But it didn't do the same for a female professor. In 1940, Congressman Samuel Dickstein, a Democrat from New York, introduced legislation to extend this provision to the husband and unmarried children of a woman professor. The Roosevelt administration blocked the measure. Secretary of State argued that since the 1924 Act had referred only to men, that proved that it was not the intention of Congress to give women the same status. Therefore, he said, quote, the proposed amendment is discriminatory and therefore is not deemed desirable. Eventually, in 1939, the State Department agreed to a modest change in the requirements, apparently in response to pressure from the president of Princeton University and perhaps other college presidents who had wanted to add German Jewish scholars to their faculties. Secretary Hall agreed that if a professor had been fired, quote, for reason beyond his control, such as discrimination on account of race, religion, or political option, he may be regarded as meeting the requirement of the law relating to past service as a professor. But at the very same time, Assistant Secretary of State George Messersmith was reminding consuls to examine with unusual care all non-quota immigrants to ensure that they wouldn't become public charges. This case is interesting because it is hard to know, it is not hard to know that Messerschmitt had in mind what he had in mind with regard to Jewish professors. Because just a few years earlier, he authored a confidential report to Secretary Hall in which he specifically belittled attempts to bring professors from Germany. Referring to the New School for Social Research in New York and other institutions that were interested in hiring refugee scholars, Messerschmitt opposed admitting them on the ground that many of the Jewish professors were socialists of an advanced type, hold ideas which are totally out of accord with our own social and economic ideas prevailing in the United States. Some, said Messerschmitt, hold ideas which, while designed as liberal, are in reality in direct opposition to our own social order. He sent similar reports. He sent to few people, and stressing that, again, a quote, we cannot fill our own universities with foreign professors who are alien to our thought and will influence our youth in a direction not in line with our national policy and our cultural life. Such professors, quote, were a danger to us, and it is a danger which we cannot ignore. The other group, let's say, we won't talk about cantors, but about rabbis. The same restrictions used against professors were used in the case of rabbis and cantors. They had to prove they had been employed full-time as rabbis for the previous 2 years. They had to have in hand a signed contract for a position with a congregation in the United States. And the salary that was being offered to them had to impress the consul as sufficient. They entered in the interviews with the applicant, they entered to such details, and he said, well, I have, the salary is not much, but they offer me meals, and I can manage, and I have just a few sources. The consul asked him, tell me, how do you think to take out money from Germany? I mean, they were abusive in my point. The question that they ask and the things that they do, not speaking, postponing each day when the applicant came, he heard about new demands that he has to add. There was never a very clear definition of all the things that he has to prepare. And that happened with the rabbis. I'll give you an example. One attempt by a New York congressman, Charles Buckley, to bring over, it's a famous case, 25 rabbis as non-quota immigrants was rejected in 1939. Now listen why. Because they didn't have contracts with 25 separate synagogues in the United States. Okay, according to the Immigration and Naturalization Service, a total of only 1,998 foreigners were admitted to the United States between 1933 and 1941 as non-quota ministers. and we can assume that some portion of them were Christian ministers, not rabbis. Now, the last group is students. One might expect that there would have been a more moderate approach to students, since they were admitted for only a temporary period. A person applying for a non-quota student visa had to show proof not only that he had been admitted to study at an American university, but also that he had sources of support for the duration of his studies. He also had to prove that he had a fixed domicile in another country to which he would return after his studies. Again, that was not an easy thing to do for someone who had been exiled from his native country. During the first years of the Nazi regime, let's say until 1935, until the Nuremberg laws, until then, the number of German Jewish students applying for student visa was relatively small. The gravity of the situation was not yet fully evident, and families were reluctant to part from their children. But ironically, when they were still able to meet the visa requirement, students were less enthusiastic to leave. Later, when they faced persecution and sought a way out, it was more difficult to convince consuls that they would be able to return to Germany after finishing their studies. In 1939, for example, there are plenty of examples, but I chose one which maybe it's typical to the attitude and in my eyes, the abuse of consuls toward applicants. They preferred to deny. It was easier for them to say no or to come tomorrow, come the next day, than accept. The same thing we had with affidavits, which I didn't talk about the regular thing, but affidavits were the same thing. No one knew how many relatives has to sign, how rich they must be. Everything was secret, cloudy, and it was always an excuse for the consul to ask for more, for another affidavit, for another thing, for another information. Sometimes the lawyer who certified the financial report was not acceptable, all kind. And I must give you one example which I felt terrible. It happened to a couple that the husband got permission to go to the United States, and the woman in Germany, and the woman and her 3 children were left. Now she asked she was on another quota, that's why she was still waiting in Germany. When she came to the consul, he said, "He is your husband? Can you show me a proof?" So she took out the ktuba, and she showed him, and he said, "I'm very sorry, this is not enough. Your husband has to go from America," 38 I'm speaking, to go from America to where you were married, to marry you in civil law, and then will approve you as a, I mean, can you, okay, I cannot say more. Okay, about the students. So a person, I told you the requirements. I'll give you the example. In 1939, the Consul General in Berlin, Raymond Geist, informed Dropsy College in Philadelphia that a visa was not being granted to a student named Faber, who had been admitted to Dropsy, quote, by reason of the fact that he is a potential refugee from Germany and hence is unable to submit proof that he will be in position to leave the United States upon the completion of his schooling. Even after the Department of Labor, and by the way, I want to take the opportunity to tell you that one person who did a lot for Jewish refugees in 1933, in 1934, in 1938, when she convinced Roosevelt to prolong the stay of people already on visitor visa in the United States, to prolong. So she was the Secretary of Labor, Frances Perkins, and I wrote about her, and I'm full of, I don't know, she was one of the fairest and most helpful people, maybe one in the cabinet, and always fighting with the State Department about helping to the Jews. Anyway, so even after the Department of Labor recommended the student applicant only be required to sign an affidavit that it was their intention to return, that was not enough. The State Department continued to refuse to accept anything less than definite proof that they would be able to return. And that was, of course, impossible. Though the law did not oblige the consul to deny student visa unconditionally, Guy's decision seemed nevertheless to stem from a strict policy. Maurice Waldman, he was the executive secretary of the American Jewish Committee, wondered whether, quote, American consul was just as particular in cases where non-Jews were concerned. As a result, the number of students admitted to the United States as non-quota immigrants was very small. In conclusion, to sum up, and there is a whole group that I can't deal with it in such a short time, but I recommend you look into it, the cases of visitors, of people who came to the United States on visitor visa. So in conclusion, American domestic and international constraints no doubt played a crucial role in United States immigration policy. National and political interests took precedence over human consideration. President Roosevelt's explanation for the reluctance of the policymakers in Washington to bend or change the law to enable mass immigration into the United States. It doesn't, however, fully explain why the Roosevelt administration, including the consuls, who were the decision maker on the spot, chose to adopt a selective and biased interpretation beyond the rules with regard to German Jews, so that the number of visas granted was well below the official quota. Consular discretion often led to a policy significantly stricter than legally required. By all indication, the consuls followed the restrictive policy favored by the Department of State. But the balance of evidence conveys that they withheld visa more readily from Jewish applicants, including non-quota immigrants. On the basis of evidence, it is difficult to escape the conclusion that to a large extent, anti-Semitism was responsible for their Adamic stand. Anti-Semitic beliefs, both overt and latent, found their way frequently enough into their consideration to warrant a link between anti-Semitism and immigration and refugee policy on the eve of World War II. If President Roosevelt had been truly a humanitarian, a champion of the forgotten man, then his immigration policy would have reflected that in some way. Let us assume that he could not convince Congress to liberalize the existing quota. Let us assume it was politically too risky to admit refugee by executive order. But if he was genuinely interested in helping the Jews within the existing laws, his administration could have taken advantage of the loopholes that already existed in the laws, as did Francis Perkins. They could have regarded refugee as a separate category. They could have looked more kindly upon applications from professors, students, and rabbis. Instead, they did exactly the opposite. They went out of their way to make it even harder for any Jewish refugees to come to America. And I want to finish with a sentence taken from a book written by Dorothy Thompson, Refugees. I don't know if you are familiar with it. It was published in 1938, and she says, quote, "And so a defeatist attitude toward the refugee problem created by the opponents of democracy becomes a defeatist attitude toward democracy itself." Thank you.
Mr. Zucker, we are running very much over time, and I will ask you for a special arrangement. There may be persons in the audience who would like to ask you a question or so, and I would like to ask you to meet with them in the adjoining room so that we can
No problem.
they can ask these questions.
No problem.
Thank you. And we will proceed to with our last speaker so that we can make our connection lunch.
Good. No problem. Lunch, food, how can I resist?